Oh, hey folks, Elder Law Care Attorney, Patrick Kelleher at elderlawcare.com. Welcome, Elder Law Care Warriors. Folks, today, subscriber sent an email with the age-old question, hey Patrick, do I need a will and a trust? Or do I need a trust and a will? Do I need both? Folks, great question. Pull up your chair, get your pen out, because let's learn what may be the best solution for you to slay that metaphorical four-headed beast right there. Folks, first and foremost, number one, a will. Just as a reminder, if you haven't read my book yet, a will is typically your admission ticket to probate court, right? Because a will does not avoid probate, and then a family's going to show up. Your family will show up at the estate probate attorney's office with a dreaded ugly milk crate. You don't want that, folks. And then the probate attorney may be charging at their firm hourly rate $400 or $500 an hour or more, possibly in some communities, for a year or two, or sometimes longer, depending on the circumstances. You don't want to do that. So, folks, really important to know that a will typically is woefully insufficient to properly protect your affairs from probate court, taxman, bloodline protection, or nursing home. Will's not going to cut it, folks. Will is your admission ticket to probate court. So the recommendation, folks, the better legal tool is the trust. Or think of your trust like a treasure chest. Have your estate elder law attorney create your trust. But I always say to our clients, it's not a magic red book, Bill and Mary, because you have to get your treasures into your treasure chest, which is a process of trust funding or asset retitling. Because sadly, people die, but trust do not. And that's the game changer, because trust funding, a funded trust, getting your treasures in there, your name, Bill and Mary as individuals, to Bill and Mary as trustees of their trust. Game changer, because that's where the rubber meets the road. That is where all the magic happens. That is the metaphorical sword and shield that slays this metaphorical four-headed beast, the trust. So another layer of this, or another piece of this, folks, is, do I still need a will, Patrick, when I'm creating that trust and funding my assets in there? And the answer is yes. Why, folks? Because it's prudent and wise, from my experience, when it comes to estate and elder law, to have belt and suspenders, okay? Especially if someone's going through a season or a storm, right? Think of your trust like your belt. Think of your will, but this is not a standard simple will. We call it a pour-over will, P-O-U-R, like a pitcher of water. I have my tea right here. A pitcher of water or tea. And you're pouring that into the trust. But you're only using that pour-over will as a backup or a safety net. Because again, going back to the original reference, the original rule, your will typically is your admission ticket to probate court. A pour-over will also is the admission ticket to probate court. So a pour-over will is simply a backup or a safety net. Let me give you an example. Bill and Mary come into their estate elder law attorney. They create their trust, their treasure chest. They have 10 assets. They got their home and 9 other assets, all in their treasure chest, okay? However, Bill and Mary forgot about another asset. They overlooked an old bank account, or maybe the automobile. That's a common asset that leaks off to the probate court. Now, they go up to their cloud, they get hit by the bus of life prematurely, unexpectedly, and that asset, that 11th asset, never gets into their trust. Guess what? That pour of a will is going to legally pour that asset, P-O-U-R. You still have to file the will at the probate court. One of my colleagues calls it a legal pooper scooper, because it's still going to be a little messy. Because why? You have to pay probate attorneys, likely pay probate court costs, maybe even put creditors on notice like Medicaid. You don't want that either in other creditors that you opened a probate with legal newspaper publications. All the messes and stresses of probate. You don't want it. Again, necessary, because people do overlook assets, as well as you're journeying through life, folks also acquire new assets. They open a new CD, they buy a new car, even after they get all their treasures in there. Hence the reason why you need both. Belt is the trust, and the suspenders is that pour-over will. There you have it, folks. Any other questions? Post a comment, a question on our YouTube channel, and a member of our elder law care team will get back to you as soon as possible. Be sure to subscribe and click that notification bell, because we will keep you updated as we release more educational elder law videos. If you like to educate and inform yourself further, strongly recommend pick up a copy of my book on Amazon, Patrick Kelleher, How to Avoid the Four-Headed Monster of Estate Planning in Elder Law, because you will learn a lot. Thanks for joining us here today Elder Law Care Warriors at elderlawcare.com.